Laws, Chapter 9. The Administration of Justice.
After discussing the natural order of legislation, the next topic to address is lawsuits. We have already described lawsuits related to agriculture, but we have yet to discuss the more important ones. Once we have mentioned them by their usual names, we will proceed to determine the appropriate punishments for each offense and who will serve as judges.
Very well.
It is disgraceful to legislate, as we are about to do, for all the details of crime in a state that is supposed to be well regulated and conducive to virtue. To assume that in such a state there will be someone who commits crimes as heinous as those in other states, and that we must legislate in advance to deter and punish them, is shameful. However, since we are not like the ancient legislators who gave laws to heroes and demigods, being mere mortals legislating for other mortals, it is not uncharitable to anticipate that one of our citizens may be like a seed that has touched an ox's horn, with a heart so hardened that it cannot be softened, just as those seeds cannot be softened by fire. Among our citizens, there may be those who cannot be controlled by the strength of the laws. For their sake, though it is an unpleasant task, I will establish my first law regarding the theft of temples in case anyone dares to commit such a crime. I do not expect or believe that any well-raised citizen will ever succumb to this temptation, but their servants, strangers, and the servants of strangers may be guilty of many impieties. With them in mind, and considering the weakness of human nature in general, I will establish a law regarding temple robbers and other incurable or almost incurable criminals. Since we have already agreed that such laws should have a brief introduction, we can speak a few words of admonition and exhortation to the criminal who is tempted day and night by a tormenting desire to rob a temple. We will say to him, "Sir, the impulse that drives you to rob temples is not a normal human ailment, nor is it a divine punishment. It is a madness that arises in a person due to the ancient and unexpiated crimes of their ancestors, a curse that keeps recurring. You must guard against this impulse with all you might, and we will explain how you can do so. When such thoughts enter your mind, go and perform expiations, go as a supplicant to the temples of the gods who avert evil, seek the company of those who are considered good among you, listen to them, and try to emulate them. Remember that every person should honor what is noble and just. Avoid the company of the wicked, flee and do not turn back. If your disorder is alleviated by these remedies, then all is well. But if not, then acknowledge that death is nobler than life and depart from this world. These are the preludes we sing to all who entertain thoughts of unholy and treasonous actions. To those who listen, the law has nothing more to say. However, to those who are disobedient once the prelude is over, cry out loudly, "Anyone caught in the act of robbing temples, whether they are a slave or a stranger, shall have their evil deed engraved on their face and hands. They shall be beaten with as many stripes as the judges see fit and be cast out of the land naked. If they endure this punishment, they will regain their senses and improve. For no penalty inflicted by the law is intended for evil, it either makes the person who suffers it better or at least not worse than they would have been. But if any citizen is found guilty of a great or unspeakable wrong, whether against the gods, their parents, or the state, let the judge deem them incurable, considering that after receiving an excellent education and upbringing from their youth, they have not refrained from committing the most heinous crimes. Their punishment shall be death, which for them will be the least of evils. Their example will serve as a lesson to others, as they perish ingloriously and are cast out of the land. However, let their children and family, if they avoid following in their father's footsteps, be honored and praised for escaping from evil to good. None of their possessions should be confiscated by the state, as the lots of the citizens should always remain equal. Regarding the imposition of fines, if a person is found to have committed an offense deserving of a fine, they shall pay the fine if they possess more than their allotted share. They shall not pay more than that. To ensure accuracy, let the guardians of the law consult the records and inform the judges of the precise truth, so that no lots remain uncultivated due to a lack of funds. However, if someone deserves a greater penalty, they shall undergo a lengthy and public imprisonment and be dishonored, unless some of their friends are willing to act as sureties and help them pay the fine, thus securing their release. No criminal shall go unpunished, not even for a single offense, nor if he has fled the country, but let the penalty be according to his deserving death, imprisonment, corporal punishment, public humiliation, exile to a temple on the outskirts of the land, or let him pay fines, as we mentioned before. In cases of death, let the judges be the guardians of the law, and a court selected by merit from the previous year's magistrates. However, the procedures for bringing cases to court, serving summonses, and similar matters can be left to the younger generation of legislators to determine. We must decide on the manner of voting ourselves. Let the vote be given openly, but before voting, let the judges sit in order of seniority across from the plaintiff and defendant, and let all citizens who can spare the time hear and take a serious interest in listening to such cases. First, the plaintiff shall make one speech, and then the defendant shall make another, and after the speeches have been made, the eldest judge shall begin to question the parties and conduct a thorough investigation into what has been said. And after the eldest judge has spoken, the rest shall proceed in order to question either party about any deficiencies in the evidence, whether in statements or omissions, and if a judge has no questions, they shall pass the examination to another judge. And all the judges shall set their seals on the relevant parts of the proceedings and place the documents on the altar of Hestia. On the next day, they shall meet again, and in the same manner, ask their questions and go through the case, and once again set their seals on the evidence, and when they have done this 3 times, and have had enough witnesses and evidence, each of them shall give a sacred vote, after promising by Hestia that they will decide justly and truthfully to the best of their ability, and thus they shall conclude the lawsuit. Next, after matters concerning the gods, comes matters concerning the dissolution of the state. Whoever, by allowing a person to gain power, enslaves the laws and subjects the city to factions, using violence and inciting sedition against the law, we shall consider them the greatest enemy of the entire state. But someone who does not participate in such actions, and being one of the chief magistrates of the state, is unaware of treason, or, knowing about it, does not intervene on behalf of their country due to cowardice, we must consider them as bad. Every person of worth will inform the magistrates and bring the conspirator to trial for attempting to violently and illegally change the government. The judges for such cases shall be the same as those for temple robbers, and let the entire proceeding be conducted in the same manner, and the majority vote shall condemn the accused to death. However, let there be a general rule that the disgrace and punishment of the fathers shall not be visited upon the children, except in the case of someone whose father, grandfather, and great-grandfather have successively undergone the penalty of death. The city shall send such individuals away with all their possessions to the city and country of their ancestors, retaining only their designated share. And out of the citizens who have more than one son who is at least 10 years old, they shall select 10 whom their father or grandfather on either side shall appoint, and they shall send the names of those selected to Delphi, and the one chosen by the god shall be established as the heir of the family that has failed, and may they have better fortune than their predecessors.
Very good.
Once again, let there be a third general law regarding the judges who are to give judgment, and the procedure for conducting trials against those who are accused of treason, and as for the fate or departure of their descendants there shall be one law for all 3, for the traitor, the temple robber, and the one who violently subverts the laws of the state. For a thief, whether they steal much or little, and whether from sacred or secular places, and these are not the only differences in theft since they come in many forms, should not the legislator adapt to them and impose entirely different penalties? Excellent. I was speaking too quickly, Cleinias, and you interrupted me and brought me to my senses, reminding me of what had already occurred to my mind, that legislation has never been properly worked out, as I may say in passing. Do you remember the analogy I made, comparing the men for whom laws are now made to slaves who are treated by other slaves? For you can be very sure that if one of those untrained doctors who practice medicine without knowledge were to come across a skilled physician talking to his educated patient, using almost philosophical language, starting from the beginning of the illness and discussing the entire nature of the body, the untrained doctor would burst into laughter. He would say what most of those who are called doctors always have on the tip of their tongues. "Foolish fellow," he would say, "you are not healing the sick man, but you are educating him, and he does not want to become a doctor, but to get well."
And would he not be correct?
He would, and he might point out that discussing laws, as we are currently doing, is providing citizens with education rather than actual laws. That would be quite an insightful observation.
Very true.
But we are fortunate,
In what way?
because we are not obligated to create laws, but rather we can consider every form of government and determine what is best and most necessary, and how to implement them. And right now, we can choose what is best or most necessary if we wish to. Which should we do?
It is ridiculous, stranger, for us to propose such an alternative, as if we were legislators bound by some urgent necessity that cannot be postponed until tomorrow. But we, by the grace of heaven, can gather a heap of materials like stone gatherers or beginners of a composite work, and from this, at our leisure, select what is suitable for our planned construction. Let us then imagine ourselves to be at leisure, not building out of necessity, but rather like people who are partly gathering materials and partly assembling them. And we can honestly say that some of our laws, like stones, are already fixed in their places, and others are readily available.
Certainly, in that case, Cleinias, our understanding of law will be more in line with nature. Because there is another matter concerning legislators that I must earnestly ask you to consider.
What is it?
There are many writings to be found in cities, and among them are discourses composed by legislators as well as by other individuals.
Indeed.
Should we pay more attention to the writings of those others, poets and the like, who have recorded their advice about how to live, whether in verse or prose, rather than the writings of legislators? Or should we pay the most attention to the writings of legislators?
Yes, we should pay the most attention to them above all others.
And should the legislator alone among writers refrain from expressing his opinion about what is beautiful, good, and just, and not teach what they are and how they should be pursued by those who intend to be happy?
Certainly not.
And is it disgraceful for Homer and Tyrtaeus and other poets to provide evil instructions in their writings about life and human pursuits, but not as disgraceful for Lycurgus and Solon and other legislators who were also writers? Is it not true that among all the writings to be found in cities, those that relate to laws, when you unfold and read them, should be by far the noblest and the best? And should not other writings either agree with them or, if they disagree, be considered ridiculous? We should consider whether the laws of states should have the character of loving and wise parents, rather than tyrants and experts who command and threaten, and after writing their decrees on walls, go their own way. And when discussing laws, we should take the gentler view of them, which may or may not be attainable. In any case, we will show our willingness to entertain such a view and be prepared for whatever the outcome may be. And may the outcome be good, and if God is gracious, it will be good.
Excellent, let us do as you say.
Then let us now carefully consider, as we proposed, what pertains to temple robbers, all kinds of thefts, and offenses in general. And we should not be bothered if, in the process of legislation, we have enacted some things and have not made up our minds about others, because we are not yet legislators, but we may soon become them. Let us, if you please, consider these matters.
By all means.
Regarding all things honorable and just, let us then strive to determine how consistent or inconsistent we are with ourselves, and how the many, from whom we should at least profess a desire to differ, agree or disagree among themselves.
What inconsistencies do you observe in us?
I will try to explain. If I am not mistaken, we all agree that justice, just individuals, things, and actions are all beautiful. And if someone were to argue that just individuals, even when physically deformed, are still perfectly beautiful because of the excellent justice of their minds, no one would find any inconsistency in this.
They would be completely correct.
Perhaps, but let us further consider that if all things that are just are fair and honorable, then the term all must include just sufferings, which are the consequences of just actions.
And what is the conclusion?
The conclusion is that a just action, in partaking of justice, also partakes to the same degree of fairness and honor.
Certainly.
And if a suffering partakes of justice, should it not also be admitted partaking to the same degree of fairness and honor, if we consistently follow the argument?
True.
But if we admit that suffering can be just and yet dishonorable, and we apply the term dishonorable to justice, will not justice and honor disagree?
What do you mean?
It is not difficult to understand. The laws that have already been enacted seem to contradict what we are saying.
Contradict what?
If I am not mistaken, we had enacted that temple robbers and those who were enemies of law and order could justly be put to death, and we were in the process of making various other similar enactments. But we stopped short, because we saw that these sufferings are infinite in number and degree, and that they are, at once, the most just and the most dishonorable of all sufferings. And if this be true, are not the just and the honorable at one time all the same, and at another time in the most diametrical opposition?
Such is the case.
In this discordant and inconsistent fashion does the language of the many rend asunder the honorable and just.
Very true, stranger.
Then now, Cleinias, let us see how far we ourselves are consistent about these matters.
Consistent in what?
I think that I have clearly stated in the former part of the discussion, but if I did not, let me now state.
What?
That all bad men are always involuntarily bad, and from this I must proceed to draw a further inference.
What is it?
That the unjust man may be bad, but that he is bad against his will. Now that an action which is voluntary should be done involuntarily is a contradiction, wherefore he who maintains that injustice is involuntary will deem that the unjust does injustice involuntarily. I too admit that all men do injustice involuntarily, and if any contentious or disputatious person says that men are unjust against their will, and yet that many do injustice willingly, I do not agree with him. But, then, how can I avoid being inconsistent with myself, if you, Cleinias, and you
Say to me, well, stranger, if all this be as you say, how about legislating for the city of the magnates? Shall we legislate or not? What do you advise? Certainly we will, I should reply. Then will you determine for them what are voluntary and what are involuntary crimes, and shall we make the punishments greater of voluntary errors and crimes and less for the involuntary? Or shall we make the punishment of all to be alike, under the idea that there is no such thing as voluntary crime?
Very good, stranger, and what shall we say in answer to these objections?
That is a very fair question. In the first place, let us
Do what?
Let us remember what has been well said by us already, that our ideas of justice are in the highest degree confused and contradictory. Bearing this in mind, let us proceed to ask ourselves once more whether we have discovered a way out of the difficulty. Have we ever determined in what respect these two classes of actions differ from one another? For in all states and by all legislators whatsoever, two kinds of actions have been distinguished, the one voluntary, the other involuntary, and they have legislated about them accordingly. But shall this new word of ours, like an oracle of God, be only spoken, and get away without giving any explanation or verification of itself? How can a word not understood be the basis of legislation? Impossible. Before proceeding to legislate, then, we must prove that they are two, and what is the difference between them, that when we impose the penalty upon either, everyone may understand our proposal, and be able in some way to judge whether the penalty is fitly or unfitly inflicted.
I agree with you, stranger, for one of two things is certain: either we must not say that all unjust acts are involuntary, or we must show the meaning and truth of this statement.
Of these two alternatives, the one is quite intolerable. Not to speak what I believe to be the truth would be to me unlawful and unholy. But if acts of injustice cannot be divided into voluntary and involuntary, I must endeavor to find some other distinction between them.
Very true, stranger, there cannot be two opinions among us upon that point.
Reflect, then, there are hurts of various kinds done by the citizens to one another in the intercourse of life, affording plentiful examples both voluntary and involuntary.
Certainly.
I would not have anyone suppose that all these hurts are injuries, and that these injuries are of two kinds, one voluntary and the other involuntary, for the involuntary hurts of all men are quite as many and as great as the voluntary. And please to consider whether I am right or quite wrong in what I am going to say, for I deny, Cleinias, and
That he who harms another involuntarily does him an injury involuntarily, nor should I legislate about such an act under the idea that I am legislating for an involuntary injury. But I should say that such a hurt, whether great or small, is not an injury at all, and on the other hand, if I am right, when a benefit is wrongly conferred, the author of the benefit may often be said to injure. For I maintain, O my friends, that the mere giving or taking away of anything is not to be described either as just or unjust, but the legislator must consider whether mankind do good or harm to one another out of a just principle and intention. On the distinction between injustice and hurt he must fix his eye, and when there is hurt, he must, as far as he can, make the hurt good by law, and save that which is ruined, and raise up that which is fallen, and make that which is dead or wounded whole. And when compensation has been given for injustice, the law must always seek to win over the doers and sufferers of the several hurts from feelings of enmity to those of friendship.
Very good.
Then as to unjust hurts, and gains also, supposing the injustice to bring gain, of these we may heal as many as are capable of being healed, regarding them as diseases of the soul, and the cure of injustice will take the following direction.
What do you mean by direction?
When someone commits an injustice, whether big or small, the law will warn and compel them to never repeat the same action, or at least to do it less frequently and voluntarily. They must also compensate for the harm caused. The law can achieve this through various means, such as using words or actions, pleasure or pain, granting or revoking privileges, imposing fines, or giving gifts. The goal is to make people hate injustice and love or not hate justice. This is the most noble task of the law. However, if the legislator identifies someone who is incurable, they will establish a law and penalty for them. The legislator knows that such individuals gain no benefit from continuing to live, and that their departure would serve as an example to others not to offend, while also removing bad citizens from the city. In such cases, and only in such cases, the legislator should impose death as the punishment for offenses.
Your explanation seems reasonable, but could you clarify the difference between hurt and injustice, as well as the complexities of voluntary and involuntary actions?
I will try to do as you request. Regarding the soul, it is accepted that one aspect of its nature is passion. Passion can be described as a state or a part of the soul, and it is difficult to resist and control. It often overthrows many things through irrational force.
That is true.
Pleasure is not the same as passion, it has an opposing power. Pleasure persuades and deceives to achieve its desires.
That is correct.
It can be said that ignorance is a third cause of crimes. Ignorance can be divided into two types: simple ignorance, which leads to minor offenses, and double ignorance, which is accompanied by a false belief in one's own wisdom. Those who possess the latter type of ignorance believe they know about matters they know nothing about. The legislator considers this second type of ignorance, when combined with power and strength, to be the source of great and monstrous crimes. However, when it is accompanied by weakness, it only results in the mistakes of children and old people. In such cases, the legislator will treat them as errors and establish laws that are the mildest and most merciful.
You are right.
We often observe that some individuals are superior to pleasure and passion, while others are inferior to them. This is true.
Certainly.
However, no one has ever claimed that one person is superior to ignorance while another is inferior to it.
That is absolutely true.
We are discussing the motives that drive people to fulfill their desires, even though individuals may often be pulled in opposite directions by these motives.
Yes, that happens frequently.
Now, I can clearly and unambiguously define what I mean by the just and unjust, according to my understanding. When anger, fear, pleasure, pain, jealousy, and desires dominate the soul, regardless of whether they cause harm or not, I consider this to be injustice. On the other hand, when the opinion of the best, wherever it may reside in human nature, governs the soul and guides the actions of every individual, even if it is sometimes mistaken, what is done in accordance with this opinion and the principle that follows it, which is best for the overall life of a person, is considered just. Although many consider harm caused by mistake to be involuntary injustice, let us not argue about names. Having outlined 3 sources of error and refreshed our memory, let us move on. One source is the painful emotions we call anger and fear.
That is correct.
The second source consists of pleasures and desires, and the third source is hopes that aim for true opinions about what is best. The third source can be further divided into 3. Therefore, we now have 5 sources of actions, and we will establish 2 types of laws for these 5 sources.
What are the 2 types?
One type applies to actions committed with violence and in broad daylight, while the other type applies to actions done in secrecy and deceit, or sometimes with both violence and deceit. The laws concerning the latter type should be strict.
Naturally.
Now, let us return from this digression and complete the task of legislation. We have already enacted laws regarding those who rob the gods, traitors, and those who corrupt the laws to overthrow the government. It is possible for someone to commit these crimes while in a state of madness, affected by illness, under extreme old age, or in a fit of childish playfulness, behaving no better than a child. If this can be proven to the judges assigned to the case, upon the appeal of the criminal or their advocate, and it is determined that the individual was in such a state when they committed the offense, they will only be required to compensate for the harm caused to another. They will be exempt from other penalties unless they have killed someone and have blood on their hands. And in that case, he shall go to another land and country, and live there for a year. If he returns before the designated time or sets foot on his native land, he shall be imprisoned for 2 years by the authorities and then released. Now, let us discuss laws regarding different types of homicide, starting with violent and involuntary homicides. If someone unintentionally kills a friend during an athletic contest or public games, and the friend dies either immediately or later due to the injuries sustained, or if a similar misfortune occurs during war, military exercises, or sanctioned contests, whether armed or unarmed, the person responsible shall be considered innocent after undergoing purification according to the law brought from Delphi regarding these matters. The same applies to physicians. If their patient dies against their will, they shall be considered blameless by the law. If someone unintentionally kills another person with their own hand, whether they are unarmed or holding a weapon or dart, or if they kill them by giving them food or drink, or by using fire, cold, or suffocation, whether they commit the act themselves or through others, they shall be considered the perpetrator and shall face one of the following penalties. If they kill someone else's slave, believing them to be their own, they shall compensate the slave's master for any loss or pay a penalty twice the value of the slave, as determined by the judges. However, the purification rituals required for these cases shall be more extensive and numerous than those for homicides committed during games. The interpreters appointed by the gods shall have the authority to declare what these rituals entail. If a person kills their own slave, they shall be exempt from the charge of homicide after undergoing purification according to the law. If a person unintentionally kills a free person, they shall undergo the same purification process as someone who killed a slave. But let us not forget an old tale, which goes as follows. When someone dies a violent death and had the soul of a free person in life, they become angry with the person who caused their death. Filled with fear and panic due to their violent end, when they see their murderer in familiar places, they are struck with terror and become disturbed. This disturbance, combined with the guilty memories of the murderer, is transmitted to the murderer with overwhelming force. Therefore, the murderer must avoid the victim's presence for a whole year and not be found in any place familiar to the victim throughout the country. If the deceased person is a stranger, the murderer must also stay away from the stranger's country for the same period. If someone willingly obeys this law, the deceased person's next of kin, witnessing all that has transpired, shall have pity on the murderer, make peace with them, and treat them kindly. However, if someone disobeys, neither dares to go to any temple and offer sacrifices without purification, or does not remain in exile for the designated time, the deceased person's next of kin shall bring a murder charge against them. If convicted, the punishment shall be doubled in every aspect. And if the next of kin does not proceed against the perpetrator, the pollution shall be considered to fall upon their own head. The murdered person will hold their kinsman responsible, and anyone who wishes to proceed against them may force them to be absent from their country for 5 years, as dictated by the law. If a stranger unintentionally kills another stranger residing in the city, anyone who wishes may prosecute the case according to the same rules. If the perpetrator is a resident foreigner, they shall be absent for a year. If they are a stranger, in addition to purification, whether they have killed a stranger, a resident foreigner, or a citizen, they shall be banished for life from the country governed by our laws. If they return against the law, the authorities shall punish them with death and hand over their property, if any, to the next of kin of the victim. If they are shipwrecked and washed ashore against their will, they shall reside on the seashore, wetting their feet in the sea and waiting for an opportunity to sail away. But if they are brought by land and are not in control of their own actions, the first magistrate they encounter in the city shall release them and send them unharmed across the border. If someone kills a free person with their own hand in a fit of passion, we must make a distinction for such actions. Passionate acts can be classified into two types: those where individuals cause the death of another person suddenly and unintentionally, without the intention to kill, through blows or similar actions on a momentary impulse, and immediately regret their actions, and those where individuals seek revenge after being insulted in word or deed, intentionally kill someone, and do not regret their actions. Therefore, we must consider these homicides as two types, both arising from passion, which can be considered a middle ground between voluntary and involuntary acts, but are only a semblance or shadow of either. He who holds on to his anger and seeks revenge, not immediately and in a moment, but with cunning intent and after a period of time, is like the voluntary. But he who does not hold on to his anger and seeks vengeance instantly and without premeditation, approaches the involuntary, and yet even he is not completely involuntary, but is only a representation or shadow of the involuntary. Therefore, when it comes to homicides committed in a fit of rage, it is difficult to determine whether we should consider them voluntary or partly involuntary when legislating. The best and most accurate view is to regard them as mere resemblances of the voluntary and involuntary, and to distinguish them accordingly based on whether they are done with or without premeditation. And we should impose harsher penalties on those who commit homicide with angry premeditation, and lighter penalties on those who do not premeditate but strike in the heat of the moment, for that which resembles a greater evil should be punished more severely, and that which resembles a lesser evil should be punished less severely. This shall be the guiding principle of our laws.
Certainly.
Let us continue. If anyone kills a free person with their own hand, and the act is done in a moment of anger and without premeditation, let the offender suffer in other respects as the involuntary killer would have suffered, and also undergo a 2-year exile, so that they may learn to control their emotions. But if someone kills another out of passion, yet with premeditation, they shall suffer in other respects as the former, and in addition, their exile shall be 3 years instead of 2. Their punishment will be longer because their passion is greater. The manner of their return shall be as follows, and here the law has difficulty in determining exactly, for in some cases, the murderer who is judged by the law to be worse may actually be less cruel, and the one judged to be less cruel may actually be worse and may have committed the murder in a more savage manner, whereas the other may have been gentler. But in general, the degrees of guilt will be as we have described them. The guardians of the law must take note of all these things. When a homicide of either kind has completed their term of exile, the guardians shall send 12 judges to the borders of the land. During the interval, these judges shall have informed themselves of the actions of the criminals, and they shall judge regarding their pardon and reintegration, and the homicides shall abide by their judgment. But if after they have returned home, any one of them repeats the deed in a moment of anger, let them be exiled and never return, or if they do return, let them suffer the same fate as a stranger would in a similar case. If someone kills their own slave in a fit of passion, they shall undergo a purification, but if they kill the slave of another in anger, they shall pay double the amount of the loss to the owner. And if any homicide disobeys the law and pollutes the agora, or the games, or the temples without purification, anyone who wishes may bring the next of kin to the deceased to trial for allowing it, and both the murderer and the next of kin shall be compelled to pay double fines and undergo purifications, and the accusers shall receive the fine themselves in accordance with the law. If a slave, in a fit of passion, kills their master, the relatives of the deceased may do whatever they please with the murderer, as long as they do not spare their life, and they will be considered pure. Or if the slave kills a free person who is not their master, the owner shall surrender the slave to the relatives of the deceased, and they shall be obligated to put the slave to death, but they may do so in any manner they choose. And if, which is a rare occurrence, but does happen sometimes, a father or mother in a fit of passion kills a son or daughter through blows or some other violence, the killer shall undergo the same purification as in other cases and be exiled for 3 years. But when the exile returns, the wife shall separate from the husband, and the husband from the wife, and they shall never again have children together, live under the same roof, or participate in the same sacred rituals as those whom they have deprived of a child or sibling. And anyone who is impious and disobedient in such a case may be brought to trial for impiety by anyone who wishes. If in a fit of anger, a spouse kills their wedded partner, or the partner kills their spouse, the killer shall undergo the same purification, and the term of exile shall be 3 years. And when the person who has committed such a crime returns, they shall not be involved in sacred rituals with their children, nor shall they sit at the same table as them. And any father or son who disobeys shall be liable to be brought to trial for impiety by anyone who wishes. If a sibling in a fit of passion kills another sibling, they shall undergo purification and exile, as was the case with parents who killed their offspring. They shall not live under the same roof or participate in the sacred rituals of those whom they have deprived of their siblings or children. And anyone who disobeys shall be justly subject to the law concerning impiety that pertains to these matters. If anyone is so violently angry with their parents that in the madness of their anger they dare to kill one of them, if the person who is murdered freely forgives the killer before dying, let the killer undergo the purification assigned to those who have committed involuntary homicide, and do as they do, and they shall be pure. But if he is not acquitted, the person who committed such an act shall be subject to many laws. They shall be subject to severe punishments for assault, impiety, and temple robbery, as they have taken the life of their parent. If it were possible for a person to be killed multiple times, it would be just for someone who has killed their father or mother in a fit of anger to experience many deaths. How can someone, who alone among all people is not allowed by law to kill their father or mother even in self-defense or when facing death at their hands, receive any other punishment? The legislator commands them to endure any extremity rather than commit such an act. Therefore, the appointed punishment for someone who kills their father or mother in a fit of anger should be death. However, if a brother kills a brother in a civil conflict or similar circumstances, and the other brother initiated the conflict and the killer was only defending themselves, they should be free from guilt, just as if they had killed an enemy. The same rule applies if a citizen kills another citizen or if a stranger kills another stranger. If a stranger kills a citizen or a citizen kills a stranger in self-defense, they should also be free from guilt. The same applies to a slave who kills another slave. But if a slave kills a freeman in self-defense, they should be subject to the same law as someone who kills their father. The law about the remission of penalties in the case of parricide should apply equally to all other cases. If a victim willingly forgives the guilt of homicide to another, believing that the act was involuntary, the perpetrator should undergo purification and remain in exile for a year, according to the law. Enough has been said about violent and involuntary murders committed in passion. Now, let us discuss voluntary crimes committed with injustice of every kind and with premeditation, driven by pleasures, desires, and jealousies. The greatest cause of these crimes is lust, which takes control of the soul, driven by desire. This is most found where the strongest and most prevalent passion among most people exists, the desire for wealth, which breeds endless desires for acquisition that can never be satisfied. This desire originates from natural disposition and a lack of education. The false praise of wealth, which is spread among both Greeks and barbarians, is the cause of this lack of education. They consider wealth to be the greatest good when it is only the third. In this way, they harm both future generations and them. For nothing can be nobler and better than speaking the truth about wealth in all states, that riches are meant for the sake of the body, as the body is meant for the sake of the soul. They are good, and wealth is intended by nature to serve them. Therefore, wealth is inferior to both the body and the soul, and it is the third in order of excellence. This argument teaches us that those who seek happiness should not strive to be rich, or rather, they should seek to be rich justly and moderately. In that case, there would be no need for murders in states that require the purging of such crimes through further murders. But now, as I mentioned earlier, greed is the main cause and source of the worst trials for voluntary homicide. Another cause is ambition, which creates jealousies that are troublesome companions, especially for the jealous person themselves and to a lesser extent, for the leaders of the state. A third cause is cowardly and unjust fear, which has led to many murders. When a person is doing something or has done something that they do not want anyone to know about, they may take the lives of those who are likely to expose their actions if they have no other means of getting rid of them. This is just a prelude to discussing crimes of violence in general. I must also mention a tradition that is passionately believed by many and has been passed down to them by those who are knowledgeable in the mysteries. They say that such deeds will be punished in the underworld, and when the perpetrators return to this world, they will pay the natural penalty that is due to the victim and end their lives in the same manner, by the hand of another. If someone who is about to commit murder believes this and is made to fear such a penalty by this mere prelude, there is no need to continue with the proclamation of the law. But if they refuse to listen, the following law should be declared and recorded against them: whoever intentionally and wrongfully kills any of their relatives with their own hand shall, first, be deprived of legal privileges. They shall not defile the temples, the agora, the harbors, or any other meeting place, whether forbidden by people or not. The law, which represents the entire state, forbids them, and will always continue to forbid them. If a cousin or closer relative of the deceased, whether on the male or female side, does not prosecute the killer when they should and have them declared an outlaw, they shall, first of all, be involved in the pollution and incur the wrath of the gods, just as the curse of the law stirs up the voices of people against them. Secondly, they shall be liable to be prosecuted by anyone willing to seek retribution on behalf of the deceased. And anyone who seeks to avenge a murder must follow all the necessary cleansing rituals and any other commands from the gods in such cases. They should make a proclamation and then go out and compel the perpetrator to face justice according to the law. The legislator can easily demonstrate that these actions must be accompanied by prayers and sacrifices to certain gods who are concerned with preventing murders in society. However, the specific gods and the proper way to conduct these trials with respect to religion will be determined by the guardians of the law, with the assistance of interpreters, prophets, and the god. Once determined, they will proceed with the legal prosecution. The same judges who handle cases of temple plundering will preside over the trial. If the accused is found guilty, they shall be punished with death and not be buried in the country of the victim, as this would be both shameless and impious. If the accused flees and refuses to stand trial, they shall be forever banished. If they set foot in any part of the victim's country, any relative of the deceased or any citizen who encounters them first may kill them without consequence or bind them and hand them over to the magistrates overseeing the case, who will then execute them. The prosecutor must demand surety from the accused, and 3 sufficient sureties, as determined by the magistrates, must be provided. These sureties will undertake to produce the accused at the trial. If the accused is unwilling or unable to provide sureties, the magistrates will take them into custody and keep them in bonds until the day of the trial. If a person does not commit a murder with their own hands, but plans the death of another and is the instigator of the act, and they continue to reside in the city with a guilty conscience, they shall be tried in the same manner as the previous case, except for the requirement of sureties. If found guilty, their body may be buried in their homeland after execution, but in all other respects, their case shall be treated the same as the previous one. Whether a stranger kills a citizen kills a stranger, or a slave kills a slave, there shall be no distinction between murder committed directly or through planning, except for the matter of sureties. As previously mentioned, sureties shall only be required of the actual murderer, and the accuser shall bind them at the appropriate time. If a slave is convicted of voluntarily killing a free person, either directly or through planning, the public executioner shall take them to a place where they can see the tomb of the deceased and administer as many lashes as ordered by the captor. If the slave survives, they shall be put to death. If someone kills a slave who has done no wrong out of fear that they may reveal their own base and evil deeds, or for a similar reason, they shall be subject to the same penalty as if they had killed a citizen. There are certain matters that are terrible and unpleasant to legislate, but impossible not to legislate. For example, if there are cases of kinship murders, committed either by family members themselves or through their planning, out of voluntary and malicious intent, which often occur in poorly regulated and poorly educated societies and may even occur in unexpected places, we must once again recount the story we mentioned earlier, in the hope that those who hear it will be more inclined to voluntarily abstain from these utterly abominable murders. For the ancient priests have clearly stated that justice, which protects and avenges the blood of kin, follows the law of retaliation and decrees that the one who commits a murderous act must inevitably suffer the same fate. Whoever kills their father shall themselves be killed by their children at some point in the future. If they kill their mother, they shall necessarily take on a woman's nature and lose their life at the hands of their offspring in later generations. For when the bloodline of a family has been tainted, there is no other way to purify it, and the pollution cannot be cleansed until the soul that committed the act has given its life in return and appeased the anger of the entire family. These are the retributions of heaven, and such punishments should deter people. But if they are not deterred and someone is compelled by some fate to willingly and intentionally take the lives of their father, mother, siblings, or children, the earthly legislator establishes the following laws for them. The same proclamations of outlawry shall be made, and the same sureties shall be required as in previous cases. However, if they are convicted, the servants of the judges and magistrates shall kill them at a designated place outside the city where 3 roads meet. They shall then expose the body naked, and each magistrate, on behalf of the entire city, shall take a stone and throw it at the head of the deceased, thus purging the city of pollution. Afterward, they shall carry the body to the borders of the land and cast it out without burial, in accordance with the law. And what should happen to the person who kills someone who is their closest friend? I am referring to suicide, where someone takes their own life through violence, not because it is required by the law or because they have experienced some unavoidable misfortune or unbearable shame, but because they are lazy or lack courage and impose an unjust punishment on themselves. For such individuals, the rituals of purification and burial are unknown, and the next of kin should consult with interpreters and the relevant laws to determine what should be done. They should follow the instructions given to them. Those who die by suicide should be buried alone, without anyone being laid to rest beside them. They should be buried without honor in the outskirts of the land, in uncultivated and unnamed places. There should be no column or inscription marking their burial site. If an animal, such as a beast of burden, causes someone's death, except in the case of a competitor in a public contest, the deceased's relatives should bring a murder charge against the animal's owner. The appointed wardens of the area, chosen by the relatives, should preside over the trial. If the animal is found guilty, it should be killed by the wardens, and its body should be cast beyond the borders. If an inanimate object causes someone's death, except in the case of a thunderbolt or other fatal projectile sent by the gods, the nearest of kin should appoint the nearest neighbor as a judge. This will absolve the kin and the entire family of guilt. The guilty object should be cast beyond the border, just like the animals. If a person is found dead, and the murderer is unknown despite a thorough investigation, the same proclamation and ban on the murderer should be made. The authorities should proclaim in the public square through a herald that anyone who has killed a specific individual and has been convicted of murder is forbidden from entering temples or the territory of the deceased. If the murderer is discovered, they should be put to death and cast beyond the border without a proper burial. This is the law we establish regarding murder, and such cases should be treated accordingly. Now let us discuss the circumstances under which a murderer is rightfully free from guilt. If a person catches a thief breaking into their house at night to steal and kills them, or if they kill a robber in self-defense, they shall be considered innocent. Anyone who commits violence against a free woman or a young person may be killed with impunity by the victim or their father, brothers, or sons. If a person finds their spouse being subjected to violence, they may kill the perpetrator and be considered innocent under the law. Similarly, if someone kills another person while protecting their father, mother, children, siblings, or spouse from harm when they are not engaged in any wrongdoing, they shall be unquestionably innocent. This concludes our discussion on the nurturing and education of the human soul, which is essential for a person to live. We have also addressed the punishments for violent deaths. Now, let us turn our attention to acts of violence that individuals commit against one another, both voluntary and involuntary. We will attempt to categorize and determine the appropriate penalties for each type and assign them their rightful place in our laws. Even the least skilled legislator can understand that injuries and mutilations resulting from wounds should be addressed after deaths. We will divide wounds into categories, just as we did with homicides, and voluntary wounds inflicted in the heat of passion or out of fear, and wounds inflicted voluntarily and with premeditation. We must make a proclamation to the effect that mankind needs laws and must abide by them, otherwise their lives would be as chaotic as those of the most savage beasts. The reason for this is that no individual's nature can know what is best for society, and even if they do know, they may not always be able or willing to act in the best interest of society. Firstly, it is difficult for people to grasp that the true art of politics is concerned with the public good, not just individual interests. The public good unifies states, while individual interests only divide them. Both individuals and states benefit more when the state's well-being is prioritized over individual concerns. Secondly, even if someone understands this concept in theory, if they possess absolute and unchecked power, they will struggle to remain steadfast in their principles and to prioritize the public good over personal gain. Human nature will always tempt them towards greed and selfishness, causing them to avoid pain and pursue pleasure without reason. These base instincts will overshadow what is just and right, leading to the corruption of their soul and the city. If a person were born with such natural intelligence that they could comprehend the truth without any assistance, they would not require laws to govern them. Knowledge is superior to any law or order, and it would be impious to consider the mind as the subject or slave of anyone. Rather, the mind is the ruler of all. I am referring to a true and free mind that is in harmony with nature. However, such a mind does not exist, or at least not commonly. Therefore, we must settle for laws and order, which are the next best option. These laws only consider things as they exist and cannot encompass the entirety of them. This is why I have spoken as I have. Now, let us determine the appropriate penalty for someone who has harmed or injured another person. One can easily imagine the questions that need to be asked in such cases. What did they wound, or who, or how, or when? There are countless specific details that differ from one another. It is impossible to allow courts of law to determine all these things or none of them. There is one specific aspect that they must determine in all cases, the question of fact. However, it is also impossible for the legislator to personally decide what punishment should be inflicted in each of these cases, whether they are minor or major offenses.
So, what is the conclusion?
The conclusion is that some matters should be left to the courts of law, while others the legislator must decide.
What should the legislator decide, and what should be left to the courts of law?
I can respond by saying that in a state where the courts are ineffective and silent because the judges hide their opinions and secretly decide cases, or even worse, when they are disorderly and noisy like a theater, applauding or booing different speakers in turn, then there is a very serious problem that affects the entire state. It is unfortunate that legislation is necessary for such courts, but when it is necessary, the legislator should only allow them to determine the penalties for minor offenses. If the state for which he is legislating is of this nature, he must take matters into his own hands and speak clearly. However, when a state has good courts and the judges are well trained and carefully selected, it is fair and advantageous to leave the determination of penalties or punishments for the guilty to them. We should not be criticized for not legislating on all matters that judges who are far less educated than ours would be able to determine, assigning appropriate consequences for both the perpetrator and the victim. We believe that those for whom we are legislating are best suited to judge, and therefore, most matters can be left to them. At the same time, as I have mentioned before, we should provide the judges with an outline and form of the punishments to be inflicted, as we have done, so that they do not exceed the bounds of justice. It was an excellent practice that we followed before, and now that we are resuming the work of legislation, it would be beneficial for us to repeat it. Let the law regarding wounding be as follows. If anyone intends to kill another person who is not their enemy and whom the law does not permit them to kill, and they wound them but fail to kill them, the person who had the intent and inflicted the wound should not be pitied. They deserve no consideration and should be regarded as a murderer and tried for murder. However, considering the fortunate circumstances that have, in a way, favored them, and the providence that has saved both the intended victim from a fatal blow and the offender from accursed fate and calamity, as a thank offering to this deity and in order to align with their will, the law will pardon the punishment of death in such a case and only require the offender to emigrate to a neighboring city for the rest of their life, where they can retain all their possessions. But if the offender has caused harm to the wounded person, they shall provide compensation for the injury as determined by the court that decides the case, and the same judges shall decide as they would have if the person had died from their wounds. If a child intentionally wounds their parents or a servant intentionally wounds their master, the penalty shall be death. If a sibling intentionally wounds a sibling and is found guilty, the penalty shall be death. If a spouse intentionally wounds their partner with the intent to kill, they shall undergo perpetual exile. If they have young sons or daughters, the guardians shall take care of their property and have custody of the children as orphans. If their sons are grown up, they shall not be obligated to support the exiled parent, but they shall possess the property themselves. If someone who experiences such misfortune has no children, the relatives of the exiled person up to the level of first cousins, both on the male and female side, shall gather and, after consulting with the guardians of the law and the priests, appoint one citizen out of the 5,040 citizens to be the heir of the household. They should consider and reason that no household among the 50-40 belongs to the inhabitant or the entire family, but rather it is the public and private property of the state. Now the government should strive to ensure that its houses are as sacred and happy as possible. And if any of the houses are unfortunate and tainted with impiety, and the owner has no descendants but dies unmarried or childless, or if they have suffered death as punishment for murder or some other crime against the gods or fellow citizens, for which death is the prescribed penalty in the law, or if any of the citizens are permanently exiled and also childless, that house shall first be purified and undergo expiation according to the law. Then, as we mentioned earlier, let the relatives of the house and the guardians of the law gather and consider which family in the state is most renowned for virtue and good fortune, and has several sons. From that family, let them choose one and present him to the father and ancestors of the deceased as their son. For the sake of the omen, let him be called their son, so that he may continue their family, maintain their hearth, and perform their sacred rituals with better fortune than his father had. After making this supplication, they shall make him the heir according to the law, and the offending person shall be left unnamed, childless, and without inheritance when such calamities befall them. Now, there are certain things whose boundaries do not touch each other, but there is a borderland that separates them and prevents them from touching. We were saying that actions done out of passion are of this nature and fall between voluntary and involuntary. If a person is convicted of inflicting wounds in a fit of passion, they shall first pay double the amount of the injury if the wound is treatable, or 4 times the amount if it is incurable. If the wound is treatable and causes great and notable disgrace to the injured person, they shall pay 4 times the amount. And whenever someone, in injuring another, not only harms the individual but also harms the city by making them incapable of defending against enemies, they shall, in addition to other penalties, pay compensation for the loss incurred by the state. This penalty shall be that, in addition to their own required military service, they shall serve on behalf of the disabled person and take their place in war. If they refuse, they shall be liable to be convicted by law for refusing to serve. The judges who convict them shall determine whether the compensation for the injury should be 2-fold, 3-fold, or 4-fold. Similarly, if a brother wounds a brother, the parents and relatives of both sexes, including the children of cousins on both the male and female sides, shall gather. After judging the case, they shall entrust the assessment of damages to the parents, as is natural. If the estimate is disputed, then the male relatives shall make the estimate, or if they cannot, they shall refer the matter to the guardians of the law. When similar charges of wounding are brought by children against their parents, those who are over 60 years old and have children of their own, not adopted, shall be required to decide. If anyone is convicted, they shall determine whether he or she should die or receive some other punishment that is either greater than death or at least not much less. A relative of the offender shall not be allowed to judge the case, even if they are of the age prescribed by the law. If a slave, in a fit of anger, wounds a free person, the owner of the slave shall hand the slave over to the injured person, who may do as they please with the slave. If the owner does not hand over the slave, they shall themselves compensate for the injury. And if anyone claims that the slave and the injured person are conspiring together, they may argue their point. If they lose the argument, they shall pay 3 times the amount for the wrong they have done. If they win the argument, the free person who conspired with the slave shall be liable to legal action for kidnapping. If anyone unintentionally wounds another, they shall simply pay for the harm, as no legislator can control chance. In such cases, the judges shall be the same as those appointed in cases where children sue their parents, and they shall determine the amount of the injury. All the previous injuries and every kind of assault are acts of violence, and every man, woman, or child should consider that the elder has precedence over the younger in honor, both among the gods and among people who wish to live in security and happiness. Therefore, it is disgraceful and detestable to the gods to witness a younger person assaulting an elder in the city. It is reasonable that a young person, when struck by an elder, should endure their anger lightly, knowing that they will receive similar honor when they are old. Let this be the law: everyone shall respect their elders in word and deed. They shall show respect to anyone who is 20 years older than themselves, whether male or female, treating them as their father or mother. They shall refrain from laying hands on anyone who is of an age to have been their father or mother, out of reverence for the gods who preside over birth. Similarly, they shall refrain from touching a stranger, whether they are a long-time resident or a newcomer. They shall not dare to correct such a person through physical violence, whether as the aggressor or in self-defense. If someone believes that they have been struck by a stranger out of recklessness or insolence, and believes that the stranger should be punished, they should take the matter to the city authorities. However, they should not strike the stranger themselves, as this would only escalate the situation. The purpose is to keep the stranger away from the possibility of harming a citizen. The city authorities should then take the offender into custody and investigate the matter, keeping in mind their duty to the God of strangers. If it is determined that the stranger unjustly struck the citizen, they should receive the same number of blows with a whip as they inflicted on the citizen, to quell their arrogance. However, if the stranger is found innocent, the person who accused them should be warned and rebuked, and both parties should be allowed to go their separate ways. If a person strikes someone of a similar age or slightly older, who does not have children, whether it is an older person striking another older person or a younger person striking another younger person, the person who was struck should defend themselves in a fair fight without weapons, using only their hands. If someone who is over 40 years old dares to fight with another person, whether they started the fight or are defending themselves, they should be seen as rude, ill-mannered, and servile. This will be a shameful punishment that is fitting for them. Those who are obedient will readily respond to such warnings, but those who are disobedient and do not heed the initial warning will face legal consequences. If someone strikes someone older than themselves by 20 years or more, the person who is present at the scene and is not younger than the combatants, nor their equal in age, should intervene and separate them. If they fail to do so, they will be disgraced according to the law. However, if the person present is the same age or younger than the person who was struck, they should defend the injured person as they would a brother, father, or older relative. Furthermore, anyone who dares to strike an elder should be tried for assault, and if found guilty, they should be imprisoned for at least a year, or longer if the judges deem it necessary. If a stranger or resident alien strikes someone who is 20 years older or more, the same rules apply regarding the intervention of bystanders. If the guilty party is a stranger who is not a resident, they should be imprisoned for 2 years. If the guilty party is a resident alien, they should be imprisoned for 3 years, unless the court decides on a longer sentence. Anyone who was present during any of these incidents and failed to assist according to the law should be punished. If they belong to the highest social class, they should pay a fine of 1 mind. If they belong to the second class, the fine is 50 drachmas. If they belong to the third class, the fine is 30 drachmas. If they belong to the fourth class, the fine is 20 drachmas. The generals, taxiarchs, phylarchs, and hipparchs will serve as the court in these cases. Laws are created partly for the benefit of good people, to guide them in living harmoniously with one another, and partly for those who refuse to be guided and persist in their wickedness. These are the people for whom the legislator is compelled to create laws, hoping that they will not be necessary. Anyone who dares to harm their father, mother, or any older relative, showing no fear of divine punishment or the consequences in the afterlife, and disregarding ancient and universal traditions as if they are too wise to believe in them, requires extreme measures to prevent their actions. Death is not the worst fate that can befall a person, far worse are the punishments that await them in the afterlife. However, these tales of punishment have no effect on such souls, as evidenced by the fact that there are still those who kill their mothers or raise impious hands against their parents. Therefore, in such cases, the punishments inflicted during life should be as terrifying as the punishments in the afterlife, if possible. Our law shall be as follows: if a person dares to strike their father, mother, or any older relative, while being of sound mind, anyone who is present should come to their rescue, as previously stated. If a resident alien or stranger comes to the rescue, they shall be honored with the first place in the games. However, if they fail to come to the rescue, they shall be punished with perpetual exile. If the person who comes to the rescue is not a resident alien, they shall be praised. If they fail to come to the rescue, they shall be blamed. If a slave comes to the rescue, they shall be granted freedom. If they fail to come to the rescue, they shall receive 100 lashes with a whip, as ordered by the city authorities if the incident occurs in the agora, or by any city warden who is present if it occurs elsewhere in the city. If it occurs in the countryside, the commanders of the rural wardens shall administer the punishment. If those who are present at the time of the incident are residents of the same place, whether they are young or old people, they should come to the rescue and denounce the perpetrator as impious. Anyone who fails to come to the rescue shall be cursed by Zeus, the god of kinship and ancestors, according to the law. And if anyone is found guilty of assaulting a parent, they should first be permanently banished from the city and sent to the countryside. They should also refrain from entering temples, and if they do not comply, the local authorities in the countryside can punish them with physical blows or any other means they see fit. If the guilty party returns to the city, they shall be put to death. Furthermore, if any free person eats, drinks, or engages in any form of interaction with the guilty party, or even touches them voluntarily upon meeting, they shall not be allowed to enter any temple, the marketplace, or the city until they have undergone purification. They should understand that they have been tainted by a curse. If they disobey this law and defile the city and its temples against the law, and a magistrate witnesses this but fails to bring charges, this omission shall be considered a grave offense when the magistrate presents their account. If a slave strikes a free person, whether they are a stranger or a citizen, anyone present must come to the rescue or pay the previously mentioned penalty. The bystanders should bind the slave and hand them over to the injured person. The injured person may then put the slave in chains and administer as many lashes as they desire. However, after punishing the slave, they must return them to their owner according to the law and not deprive the owner of their property. The law regarding this matter shall be as follows: if a slave strikes a free person without the command of the magistrates, the owner of the slave shall receive the slave in a bound state from the person who was struck. The owner shall not release the slave until the slave has convinced the person they struck that they should be released. Similar laws shall apply to women in relation to other women, as well as to people in relation to each other.